Thank you very much for joining us. I've got Mel here, and Verinda has just joined as well from Hayes. Her audio is just connecting, so I'll just give Verinda a few minutes. Verinda, can you hear us?
Yes, I can hear you.
You've just got on in the nick of time.
Oh God, what a nightmare.
Always happens.
Always happens. We're not live yet, are we?
We are.
Oh, we are.
Started, so I was just saying hello, but I know that you often do a little bit of an intro. So do you want to
Yes.
kick off with a short intro?
I will do, yes. Morning, everyone. Sorry, Zoom issues this morning. Apparently I needed a Zoom update, so apologies for being late. So thank you once again, all of you, for joining. Welcome to Melanie. I don't think we've met you before, Melanie, on one of these webinars that we've done with
Morning.
Morning.
Yeah, no, not yet. No, first time. So go study on me, everybody.
Well, you've got big shoes to fill because they've always been great. We've got a massive turnout again, everybody. This morning, I think last count was about 170 from what Tom said. So again, sounds like another sort of topical webinar for us to host. And we are hoping, and I think some of you may well have seen it on the invite, to maybe do one face-to-face in September once everyone's got school holidays and summer holidays out of the way. So please do watch this space, because we think there is an appetite there for doing a few every now and then, maybe once a quarter in the office face to face. So watch this space for that one, and I will hand over to Fiona.
Oh, thanks, Verinda. And sorry for you've done that very well, because I've just completely put you on the spot. And what we're thinking of doing is, obviously today Mel and I are going to cover back to basics and employment tribunals, have a bit of a refresher on, I suppose, how we are seeing things progress in the employment tribunal, some kind of top tips. And the follow-up that Verinda just referred to, we were thinking about doing an in-person event where we do a mock tribunal, so we can revisit what it's actually like if you are in that tribunal setting. Hopefully we can avoid you getting there, but if not, just knowing how that process runs. So that would be potentially the follow-up event, so please do look out for that, and that will hopefully be in September. So if we just go on to the next slide, what we're covering today is just a bit of background on where ET claims are at the minute. We've seen lots of changes over the years, and unsurprisingly, there remains to backlogs with tribunal cases. So I'll give you a bit of an update on that. We'll look at how to avoid ET claims. We'll look at the process of ACAS early conciliation, which is something that I know a lot of our clients use very successfully. Mel's going to look at some procedural aspects, we'll look at some tactical tips, and then we'll look at a case study. And if you've been on our Hayes seminars before, we do like to try and make these webinars as interactive as you possibly can in this scenario. So we've got some poll questions for you, we've got the case study. Please use the Q&A and the chat function, and we will try and get through those and talk through any particular issues you've got. But if not, we've also got Mel's and my details at the end, and of course you can email us with any queries that you think of afterwards. So in terms of the kind of background and the introduction, as I mentioned, the ET system is still under pressure. There's certainly continues to be an increase in claims. We saw in 2017 the fee system was abolished, so that led to an increase in claims. We then had COVID come along, and initially, until they kind of got the CVP system, which is the online system, set up, that delayed matters. And I think as of March this year, there were just under 500,000 cases recorded as waiting to be heard. And I think depending upon which region you're in, the waiting times vary. But, we are still seeing cases being listed at, into next year, the latter end of next year. So I think remote hearings has been useful because we've seen that there is flexibility, and we are, I think certainly we're finding it for clients, you know, sometimes your witness can't attend in person, but if we can do a hybrid hearing, that is an excellent solution, and we can, you know, it enables hearings to go ahead where perhaps they otherwise might not have been able to. But the system is still under pressure. And I suppose, you know, there isn't a quick conclusion, and both claimants and respondents need to be aware of that when you go into this process. It isn't, you know, a quick turnaround, particularly in the more complex claims where you've got discrimination issues. You know, they are going to take their time to get through the system, which I suppose does in turn mean that parties will look at settlement, because, you know, do you want that piece of litigation kind of hanging over you for so many months into the future? And it does in turn lead to some settlements. It's also, of course, you know, time consuming, stressful. It incurs legal fees. If you lose, there's going to be compensation awarded. There's also, you know, judgments are now published online. So if you search online, you can find that employment tribunals results are now published. If either party requests written reasons, you can find the written reasons on the website. So outcomes are available for people to find. They're a matter of public record. And then not only are, you know, is there the compensation aspect, the fact that judgments might be published online, but, you know, tribunals can make recommendations where they uphold that a case in any particular circumstances. And a few years ago, we saw with the Jaguar Land Rover case, which concerned an employee who was transgender, who had suffered harassment. The tribunal, I think they awarded about 180,000 and then made lots of recommendations in terms of the judgment had to be read out at the board meeting. There was equality officers appointed, so they can go above and beyond that. And as a business, you may, you know, there is that negative interest. There might be media interest in a case as well. So there's lots of things to consider when you enter into this process. You know, you do hear of these substantial awards in some of the newspapers, but they aren't the type of awards we tend to see in the everyday cases, particularly unfair dismissal. We're not looking at those type of awards. Discrimination, of course, does attract more significant awards. We thought it'd be quite interesting, based on the last Employment Tribunal statistics, to ask you a couple of poll questions in relation to this. So the first question we have for you is, what is the average award in an unfair dismissal claim from the latest ET statistics? I'll just give you a few minutes to have a think about that. Right, so we've got 54% saying 25,000. 34% saying 13,000 and 13% saying 48. So clearly what this shows is we all think they're going to get more. The actual answer is 13,000. That was the average award from the last set of Employment Tribunal statistics, which was from 2020 to 2021. So remember, in unfair dismissal cases, the maximum award is up to a year's salary, which has just been capped now. That's gone up to a 105,707 is the maximum, or a year's salary, whichever is least. But the individual has to go out there and mitigate their loss. So if they are bringing an Employment Tribunal claim, the tribunal will expect to see that they've gone out there and they're making efforts to find another job. So the average award, based on tribunal statistics, you know, they aren't the significant numbers. Unfair dismissal, we're looking at an average of 13,000. Okay, so the next poll question. What was the highest award in a discrimination case from the latest ET statistics? Yeah, so we've got the majority, 52%, saying 228, and that is correct. That was in, I believe, a race discrimination case. The highest award was 228. The highest unfair dismissal award was 165. So I just mentioned the average, but the highest one was 165. There were also the highest awards for disability sex were around 225,000 and 184,000. So we can see that when we're talking about discrimination cases, there is that higher compensatory risk. Not only might somebody be looking at, what their loss of earnings are, but they'll also be looking at an injury to feelings award, which is at the discretion of the tribunal. There are different bands that apply depending upon the severity. So if we move on to the next slide, how do we go about avoiding tribunal claims? Well, I think firstly, your policies and your procedures are really important. People within the workplace need to know what's expected of them and the consequences of failing to follow the rules or meeting the standards that are required. And I think we all kind of know that within a performance context, don't we? When we're managing performance, we will be clearly saying to the employee what the standards are that we expect, how we need them to improve in their performance, and what support we're going to provide to get them to that level of performance. But it's the same with conduct as well. And that's why you will have, I'm sure, within your disciplinary policy, your rules of conduct, which set out very clearly what types of conduct can lead to action up to and including dismissal. So setting out those expectations are really important. And you as an employer will be on the back foot if you try and address an issue and the employee says, but I didn't know I wasn't meant to do that. I mean, in some instances, it's kind of a given, i.e. theft. We all know that we're not going to go to work and steal, but we do still list that within the rules. But we do often hear in response to disciplinaries, employees might say, I didn't know that was the case, or I know that's the rule, but nobody in reality sticks to it, or I know that's the rule, but our manager allowed us to do this, or I know other people who have been disciplined in the same circumstances and they didn't get the same sanction, or everybody does this, it's a widespread issue despite our rules. So it's not only having the rules in place, but it's making sure that policies are adhered to. We take action when policies aren't being adhered to, and there's that leadership from the top as well. It also might be that through our contracts, through our job descriptions, as well as our policies, we set out what our expectations are. And I think a key point in this is just making sure that our managers do lead by example. You'll be referring to those policies when you're doing a disciplinary invite letter. We might be saying that the allegation is that somebody has falsified hours forms or whatever other documentation. And then we might quote the policy that we say that they're acting in breach of. So again, clearly setting out, these are our expectations for our employees. You've failed to meet those expectations. It's very hard to argue with that because it's clear and it's in black and white. I think the other tip as well that I'd have for you in relation to this is make sure that you think about any specific conduct which is relevant for your industry. I have been in tribunal before where there was an individual who had removed price cards within a shop environment, and the employer had classified it under, I think, falsification of documents or some kind of wide rule within their rules of conduct. but the tribunals do like us to be quite specific. So if there are particular nuances to your industry, and actually something that, yes, it does come within this general, manipulation of forms, but could we add to our rules of conduct and say, this might include falsifying hours, removing this, doing that. So think as well about whether there are any specific conduct issues depending upon the type of industry that you're working with. And I think that all helps and should lead to you as an employer acting consistently in your disciplinaries. Everybody knows what the standards are. We can then also keep track of how we've dealt with things in the past, because we do often see, and I'm sure Mel's had this before, where individuals, say we're not dealing with things consistently. Other people may have been disciplined and not had the same sort of sanction imposed. But if we are clear and we're keeping record, or we know what we've done in the past, then we can say, well, yes, we have taken the same action, or where we haven't, this was the differentiating feature. Put my teeth back in. So, and I think the final thing to mention about that is your equal opportunities policy. Now, that's a real key policy, particularly when we're thinking about any sort of discrimination issues within the workplace or harassment. And you as an employer might want to rely on a reasonable steps defence, that you've taken all reasonable steps to prevent discrimination and harassment occurring within the workplace. In order to rely on that defence, you should have a robust equal ops policy in place. So again, another good reason why having your policies in order, setting out what our expectations are, is really key and is one of the first steps you take to avoid the tribunal claims. I think another area as well is your training for your managers. Managers are at the coalface. They're dealing with these issues as and when they happen, whether it's conduct, whether it's grievances, whether it's performance. They're likely to be the first ones to hear whatever the issue is. They need to know, they're not going to be an expert in employment law, but they need to know when is a red flag area, when do they need to escalate that, when do they need to seek advice from a manager to bridge that gap to identify whatever the issue is. It could be that manager who sees an inappropriate post on social media, or perhaps a message on a WhatsApp group which is not appropriate. They need to know what is the relevant step they take. Perhaps they're managing somebody on long-term sick, and they need to know how to engage with that person, given that person is probably going to feel quite isolated and as they're away from the workplace. It could be that manager who has to performance manage someone. Do they know how to do it? Do they know the importance of having those early conversations because of the impact it's going to have? A lot of these things require proactive management. Have you trained your managers to do that? Because it can cause problems if those issues haven't been dealt with. And you are busy, and managers are busy in their day job. So actually having that difficult conversation with an employee, it's one thing that you probably think, oh, well, I can put that further on down my to-do list. But actually, do they realise the consequences of that and how it can impact on the rest of the team, because they see a manager not doing what they should be doing and proactively managing? So investing in your training for your managers is important. And of course, there is a wealth of different training resources that you can use to train your managers, depending upon what your own resources are. It could be, using ACAS as a base, because they've got wonderful, bits of information on there. There's ACAS guides that can help you. It could be e-learning guides, and Freeth, we have e-learning guides on disciplinaries and grievance procedures, and it could be getting your managers to participate in that sort of e-learning. Could be organising some training. Mel and I will often go out and train managers, for a full day in terms of how to manage a raft of employment law issues. It could be that your own HR teams are trained in order to relay that training out to the wider workforce. So there's lots of different ways in which you can invest and upskill. And I do think the investment is worth it, because it minimises it minimises the impact of potential claims. Having difficult conversations early, just alluded to that, but we're going to come back to it, but that is really, really important in terms of nipping these things in the bud. Often when Mel and I get involved, it's because that issue has been left to stew, and then it kind of comes up into explosion point, and that's when the lawyers get involved. But if you can sort those issues out earlier on, you are potentially going to avoid the issues longer term. Following the ACAS Code of Practice, now, the ACAS Code of Practice on Disciplinary and Grievance Procedures, you're probably all familiar with this, but for those who aren't, ACAS, I mentioned them a minute ago, are an independent public body funded by the government, and they provide employees and employers with advice and conciliation services. And Mel's going to come on to talk to you about the conciliation service that they provide. Part of that is they produce guidance and specifically codes of practice on how to deal with certain situations. Now, the ACAS Code on Disciplinary and Grievances should be adhered to by employers as they're going through a process. So there is this code. If you aren't familiar with it, I would strongly advise you to get familiar with it. If you need a refresher, go on their website and have a look at it. It applies to all disciplinaries and grievances. It doesn't apply to redundancy situations, but it sets out the steps that you need to follow when you're disciplining someone, or if you're going through a grievance process. Now, your disciplinary and grievance policy probably mirrors it, and if it doesn't, then I would revisit that to ensure that it does mirror the standards set out in the code. That's because failure to follow the ACAS Code of Practice can lead to an uplift of up to 25% in compensation. So it is really important to ensure that the code is followed. I would say in terms of disciplinaries and grievances that I see, it is very frustrating for you as an employer where you've got a disciplinary offence that, strong evidence that misconduct or gross misconduct has occurred. Say, for example, we're thinking there's a theft in the workplace. We've got evidence. We believe that it's more likely than not that this theft occurred. We've done a reasonable investigation. We can show that. So we've gone through all the procedural points we should have, and then perhaps we've not sent that invite letter to the disciplinary, or perhaps we've not given right of appeal, or perhaps we've not mentioned the things that we should in our disciplinary invite letter. That's a failure to follow the ACAS Code of Practice. It's an easy win to ensure that we, as a minimum, adhere to the procedural standards set out in the ACAS Code. So do ensure that you're complying with that when you're going through your disciplinary and grievance processes. One thing to mention as well is there is the code, but then there's also a supplementary guidance document, which sometimes I don't think people are necessarily aware of. But if you want any further guidance on the code, there is that guidance document. Creating a culture of open communication. Again, very important. I think in all aspects of employee engagement, you will know that as HR professionals. But in terms of their experience, motivation, engagement, and business success, if employers are open and honest and transparent, then I think, that reaps lots of rewards. And of course, if employees are content, they're less likely to be bringing claims. And that's where communication breaks down. That's where we see employees becoming unsettled. There's that breakdown in communication, and that's perhaps when they start going down a litigation route. And finally, seek advice early. I think, again, Mel and I will often see this. We're asked to advise when perhaps a claim has come in and it's too late in the day. You will know as managers, as HR professionals, where actually, things are going a certain way. Perhaps just pick up the phone a little bit earlier to get a sense check on what is happening. Particularly, complex cases of discrimination, whistleblowing, they're certainly ones where it is probably worth getting a little bit of advice earlier on so that you can manage that risk. And because, of course, they don't need 2 years service, compensation isn't uncapped. And also those claims can cause a real headache because individuals could be named as respondents as well as the business. So you will know, and I think it's a judgment call, but where those claims are potentially coming, you do know that it's complex. Get advice early on in the process to minimise the impact. If we go on to the next slide, I just want to touch briefly now on the importance of early conversations. You know, I think we see this time and time again, and it might seem quite basic, as does, you know, following procedures, but I think procedures, conversations, your documentation, they are the key things in terms of minimising your risk of litigation. If you've had the conversation early on, the behaviour hasn't become entrenched. So rather than talking about a whole host of issues because they've all built up, you can break them down one by one. The longer we leave it, the worse the situation gets. And also you then get the situation which comes up an awful lot where the individual says, hang on a minute, I've been working here for ages and nobody said anything to me. Why is it taken until now? Or perhaps you've had a manager who hasn't managed the situation. You then get a new manager coming in saying, right, we're not happy with your performance. And that individual says, but nobody said anything before, you must have a personal issue with me. And then they then raise a grievance. So we need to tackle it head on. We need to put the employee on notice so that they can explain perhaps why their conduct or performance is the way it is. And we can then obviously reset what expectations are. It allows them the chance to improve or put things right. And of course, if we can do that and get them back on track without the need to go through any sort of process, that's a win-win for everyone. It prevents that detrimental impact on the team that we know can occur if someone isn't doing what they should be doing. And it also creates that culture of conversation and communication. So all really positive. And yes, it seems very basic, but it isn't done. And in many situations, and I think just taking that step and training your managers to ensure those conversations take place can be really beneficial. I'm going to hand over to Mel now, who's going to talk about ACAS early conciliation.
Thank you very much. So we're going to talk about employment tribunal procedure a little bit, but before a claim can be issued, there's a mandatory step that has to be followed by claimants, prospective claimants. And as Fiona said, ACAS provide conciliation services for employees and employers to essentially resolve their disputes. Now, historically, that process was reserved for the period after a claim was issued. And ACAS would get in touch with both of the parties once the claim was in and see if they could mediate, essentially. But often the appetite to settle a claim can be reduced by that point. Lawyers have been instructed, money has been paid out, and the further along in a process that one gets in the employment tribunal procedure, as I say, often the appetite to actually settle it can reduce the more effort and cost that has been put in. So some years ago, they brought in this requirement for mandatory early conciliation, which has to take place before a claim is issued. So anybody now wanting to issue a claim to the Employment Tribunal has to register for early conciliation. And they essentially complete a form online, setting out the broad nature of what the claim is that they intend to bring. And ACAS will contact that person and say, do you want us to conciliate? Now, the prospective claimant doesn't have to say yes. They can say, no, I don't want you to conciliate. And with that, ACAS will give them a certificate with a number on it, and the claimant can go off and issue their claim. So it's a mandatory step, but the process isn't obligatory, which sounds a bit daft. But they might say, yes, please conciliate, please help me. And ACAS will then call the prospective respondents, or the employer or the former employer, and see if they want to conciliate. And again, it's optional as to whether or not the prospective respondent says, yes, we'll talk, or no, we know exactly what this is all about and we're not interested. But if parties mutually want to have ACAS assist them with this process, there's then a period of 6 weeks in which ACAS can mediate and conciliate between the two parties to see if the matter can be resolved. If it can't, as I've said, the claimant gets a certificate, and that is the number that they have to enter when they issue a claim form. In our experience, early conciliation can be really successful, really helpful. It does have the impact of getting rid of a lot of claims before they kick off. So from our perspective, it's a useful exercise to go through if you ever receive that call from ACAS. Often there's no harm done to hear what the prospective claimant's got to say and what it is they're looking for. Because sometimes that might simply be that they want a factual reference, which costs us nothing and gets us, no bother really. So if we could just move on the slides then, please, Tom, to look at procedural aspects. So what happens when a claim is issued? Okay, despite all of our efforts to, have everything in order and have these conversations, taking early advice, ACAS early conciliation hasn't, resulted in a resolution. The claim is in, it's on our desk. We have an employment tribunal claim. What now? Well, no two claims are exactly the same. Okay, there are differences clearly in every claim that is issued, but broadly, the procedural steps that have to take place in an employment tribunal procedure are the same. And there are a few main ones that we're going to just talk about now. The first one is submitting the response. Okay, so the response to the employment tribunal claim has to be submitted within 28 days, and there is a specific form that has to be completed. Sometimes there are delays in these claims reaching you as the employer, and you might have less than 28 days by the time the Royal Mail has managed to get it to you, which can be very stressful. You are allowed to apply for an extension of time within which to complete that, and the tribunal will consider whether it's just inequitable to grant that extension. So you would need to give them full reasons on why you're seeking the extension to put the response in, and make sure that that application goes in before the deadline. Okay, but there is a form to fill in, as I say, and you can either set out the background to your defence in the response form, or you can attach a separate document, which we tend to call the grounds of resistance, and that essentially sets out what the basis of your defence is to the claim. Would focus on the claimant's specific allegations and the legal issues, and respond to the case in detail and make the main points that you want to say. The next stage, so once your response has gone in, the tribunal will usually order that parties disclose relevant documents to each other. So that's a duty by each party to disclose any documentary evidence that they've got that's relevant to the legal issues in the claim. Okay. That includes documents and evidence that don't help you. So if it is relevant to the legal issue, but it doesn't necessarily assist us, we're still under a duty to disclose it. Okay. That's ensuring that all documents disclosed are true and accurate and haven't been amended or altered. And that's a really good reminder that when you're dealing with employee related issues, that ultimately every document that you create, be it an email, a document, a letter, could eventually be disclosable in employment tribunal proceedings. That includes also internal communications between colleagues about HR matters that are ongoing. We've seen some rather unfortunate disclosures made in employment tribunal claims of things that people have said on email about claimants and wish they never had. So keep your internal communications factual, and just remember, this could, whatever I'm writing, could end up in an employment tribunal if it's pertaining to sort of an employee issue. Documents that are without prejudice or communications between you and your lawyer are not disclosable. Those sorts of documents don't go in the bundle, but if there's ever any question on that, obviously seek advice as to what you should and shouldn't be disclosing, essentially. And the duty to disclose is a continuing duty, and that means relevant documents arise or are located after you've sent that initial list of documents, you're under a duty to continue to disclose relevant documents that crop up. Okay.
Mel, I was just going to say,
yeah, please.
I raised my hand.
Oh, did you?
I was trying to find where it was, but I was just going to say on that, obviously there's a duty to disclose, but we are seeing an increasing trend in terms of, before you get to that stage, often employees are now submitting data subject access requests as well. So even if a claim isn't issued, again, you may well be asked to disclose documents. It might be, all emails between a manager and a director about, a particular person, if they're identifiable from that communication. So whether we get to claim stage or not, be aware and don't commit to paper anything you wouldn't want to see in an employment tribunal or in the data subject access request.
Really good point. Thank you. Yeah, absolutely true that the subject access request process is very much used by prospective claimants now to elicit evidence. And I suppose a further point that flows from that is ensuring that documents that are disclosed in a data subject access request are also disclosed later in the employment tribunal proceedings if they're relevant, because I have seen that occur as well, where certain documents have been offered up early but somehow not made it into the disclosure despite being highly relevant. So consistency is key, and as I say, absolutely seek advice if you're unsure. The disclosure of documents then leads into the next stage, which is the parties agreeing a bundle of documents for the hearing. Okay, and a date will be set for all of these steps. Essentially, the tribunal put down dates by which parties have to comply with these directions. And the bundle is that. It is a bundle of relevant documents for the judge to consider in the case. And it can be quite difficult to keep this proportionate, especially if you're dealing with an unrepresented claimant who wants to put every policy and every letter and every single, you know, piece of information that they might have. So, you know, sometimes arguments occur about what documents should go in the bundle. Are they relevant or not? And ultimately, it's a matter for a judge as to what they say should be admitted into the bundle. You know, if it's a big issue, if there's a huge dispute about what should go in the bundle, that can be dealt with in a preliminary application in a preliminary hearing. But if there are a few issues outstanding, most judges are content to deal with that at the start of the hearing. A judge will usually say, are there any outstanding issues? And if there's a dispute over documentation, they'll hear representations there and they'll decide whether or not that document should be included in the bundle. Some tribunals are very strict about the size of the bundle. We are seeing increasing directions that limit the number of pages that can be in a bundle, so that can make the task a bit more difficult. But ultimately, the aim is to agree with the other side, a bundle of documents for the hearing, and it's usually the employer, the respondent's job to take sufficient copies to the hearing and sort of collate the thing. Noting that electronic copies have to be sent to the tribunal in advance of hearings that are going to be taken place remotely by CVP. But check the tribunal's directions very carefully on that, because they will sometimes direct that they want you to submit the bundle electronically, but also that they might want hard copies as well. So just check very carefully what is being asked. Finally, usually the final step in the procedural part is the exchange of witness statements. Okay, these are usually exchanged at least a week or 2 weeks in advance of the hearing so that both parties can prepare their cross-examination. Witness statements can't be changed once they've been exchanged, so it's really important to get the content right. The witness statements flesh out the bones of the response. Okay, the grounds of resistance and response sort of give an outline of what our defence is. The witness statements you know, dig further into the detail, and the witness statements will refer to documents in the bundle. That's what you want to be able to do in a witness statement, is, you know, make a point, and if there's supporting evidence, or if you want to address evidence that doesn't help you, actually cross-referencing it by page number to the bundle that the tribunal has got will ensure that the judge reads that document, because it's not always the case that a judge will read a bundle from start to finish. They'll only usually consider the documents that they are directed to. So that is really important within the witness statement. And it's really important that the witness goes to the hearing as well. So if you exchange a witness statement for somebody who's not going to attend, you know, a judge might decide to disregard it altogether, or might decide to read it but apply the appropriate weight to it. If that person's not there to be questioned on what they've said, you know, there will be little weight attached to what they're saying, essentially. Okay, if we could have the next slide, please. So, tactical tips. So once a claim has been issued, whilst you have to file the response, and obviously we'll recommend that you always put in a response, you know, within the allocated time, that doesn't always mean that the case will go to a hearing. Claims sometimes just don't make it all the way there, and there are various things that can occur in that respect. One thing I want to highlight is this question of whether or not the claim is in time. Okay, so all claims in the employment tribunal have to be issued within a specified time. For the majority of them, that's within 3 months of the act complained of. So, for example, the act of discrimination complained of, or the date that the dismissal took effect in an unfair dismissal claim. If somebody's not gone through the early conciliation process, or if they've issued their claim out of time, you might have cause to actually say within your response the tribunal doesn't have jurisdiction to hear this claim. It's not in time, and there's nothing more joyous than highlighting to a tribunal, getting your calendar out and counting the days from that dismissal to the date that claim form has gone in. There's nothing more wonderful than identifying a claim is actually out of time. And you should highlight that if you think that that's the case. Yes, the tribunal have got the discretion to allow claims in out of time, you know, but it's a very legal argument. And if you think a claim has been issued out of time, you should absolutely be trying to bring that to the tribunal's attention, because it might get kicked out early. Okay. Settlement is another way in which claims disappear. We've talked about this, you know, Fiona talked about, you know, issues with employment tribunals in terms of it takes time, it takes money, there's risk, there's reputational risk with judgments online. There are lots of things to consider as to whether or not you should defend a claim, and frankly, some of them are, you know, absolutely critical to defend. You know, there'll be all sorts of things impacting, but sometimes it will make commercial sense to settle a claim, and that can happen at any time. As we've heard, it can happen in ACAS early conciliation, but it can happen right the way through the process, right in the hearing, actually, sometimes right at the beginning of the start of the case. Parties can ask the judge for half an hour to go and have a chat. So it can happen at any time. And there's never a guarantee on an outcome in an employment tribunal, okay? We can tell you as your lawyers that you have great prospects, that we feel confident that the evidence is in our favour. We can't tell you what the judge is going to decide on the day. So there is always a risk, okay? And sometimes it will be larger, sometimes it will be smaller. So settlement, you know, we see claims settled all the time. Lots of people don't want to go to an employment tribunal hearing for obvious reasons. It is stressful, it takes a lot of management time, and the claimants will have reservations too. You know, when somebody puts in a claim, they can be very buoyed up. This is about principle. They want to have their day in court, and sometimes 18 months down the line, they've moved on with their lives and they might be willing to take a settlement. Okay, so that's something to consider. And then there are processes within the employment tribunal where claims can essentially be knocked out, if you like. The tribunal don't sift claims at the outset to decide whether or not a judge thinks they've got good prospects. Okay. But you might identify that a claim has got very weak prospects, and there are various grounds on which you can apply to have a claim struck out and terminate the employment tribunal process, essentially. So a tribunal can strike out at any stage of the proceedings a claim on the grounds that it's scandalous or vexatious or has no reasonable prospects of success. If it's not being actively pursued by the claimant, so for example, if they're not complying with those case actions, disclosure, witness statements, etc., if it's not possible to have a fair hearing, or if they're conducting themselves in an unreasonable manner in the case. So there are various grounds on which you can apply for a strikeout, and that is about making an application to an employment tribunal. And again, they'll usually have a preliminary hearing to consider whether or not that's appropriate. But we do see some claims struck out. You know, it happens. In some circumstances, tribunals can issue what we call a deposit order of up to £1,000. So if the claim has little reasonable prospects of success, so not no prospects so that the claim should be struck out, but a tribunal might say to a claimant, there are little prospects of success here, and in order to continue with your claim, we want you to pay a deposit order of up to £1,000. So that's something to consider. And an unless order is the other one. So where somebody isn't complying with directions, for example, the tribunal can say, look, unless you do this by this date, your claim will be dismissed, for example. And then finally, just want to mention costs warnings. And I don't say this lightly. You know, I'm not suggesting that every employer should put a costs warning on a claimant, because it's not always appropriate. Essentially, in the employment tribunal, both parties bear their own costs. Okay, so it's not that if you win, you get your costs paid like you would in the county court. You both bear your own costs, but there are some exceptional circumstances where an employment tribunal can make an award for costs. And if a claim has no reasonable prospects of success whatsoever, you know, one option might be to write to the claimant on a without prejudice save us to cost basis, explaining to them why you think their claim is absolutely hopeless, and inviting them to withdraw, and drawing their attention to the fact that you're going to incur significant costs in defending this claim that has no prospects, and that if you're required to continue incurring costs in defending this claim and they subsequently lose, you might make an application for cost based on their unreasonable behaviour in continuing with it. So strategically, it can be very useful. As I say, it's not a suggestion that every claimant should be on the receiving end of a costs warning, but sometimes a claim will fall to you and it'll be completely hopeless, and you've got no choice but to incur cost and defend it. And in those circumstances, a cost warning sometimes has the effect of actually getting that case knocked out quite early. I think that is the end of my slide. So I think we're back to Fiona now for the case study. Oh, you're muted, Fiona.
Always one. Who does that? It's me. I was just going to say, I think I saw a couple of questions. One, we've had a question which I'll just quickly answer before we go into the case study, but one around time being paused when dealing with ACAS conciliation. Essentially, it depends. There are two different ways in which you can calculate it, but one way is essentially by counting the number of days between when conciliation started to when it finished, and then you add it on to the end. And then there's another way, isn't there, where you add essentially a month date, but that is a kind of brief summary. You need to look at each, you need to look at the dates carefully to ensure that it, the relevant timings, but that's in brief summary how it works. We've also been asked, is there a difference between the redaction process for a DSAR and the disclosure of documents? I mean, for disclosure exercise that I've been involved in, I haven't necessarily redacted. I don't know about you, Mel. Whereas with a DSAR, we may well have redacted information about other people because we don't want to identify third-party information, but that isn't necessarily the case in relation to disclosure of documents.
I would just say, yeah, there are more sort of grounds or legal bases, as it were, to not disclose certain information in a data subject access request that don't necessarily apply in the employment tribunal process. So as Fiona says, you very rarely see redactions in employment tribunal disclosure, but in a DSAR, there are more grounds upon which you can legally refuse to give certain information. As Fiona said, if it's mentioning a third party or a minor or something like that. So there can be quite discrete differences. Yeah.
And we've just had another question. Can you repeat the statement without prejudice, save us to cost? If this is stated, is the employer warning the employee they will be going for costs?
Yes. Yeah, essentially, yeah. You would head up a letter without prejudice, save us to costs. It is an attempt to resolve the situation by you inviting the person to, dispense with their claim, and you're essentially putting them on notice. You'd set it all out very clearly in the letter to them that actually if they don't withdraw, or if they subsequently lose their hopeless claim, we might bring this letter to the judge's attention and make an application for costs.
Yeah. Okay. So thank you for your questions. If you think of any more, please do just type them in. We are going to end with a case study because we like our polls, we like our case studies, which we'll just talk through. So in this case study, you have received a number of complaints from management about an assistant who has been with the company for 2 to 3 months. They complain that she is often late and has a poor attitude to work. She is approaching the end of the 3-month probationary period. What would your initial concerns be, and how would you handle this? So feel free to put any comments in the chat or in the Q&A. For me, I would certainly be thinking about, okay, so there's been complaints. Have we addressed, it goes back to that early conversation point, have we addressed that with the individual? Have we explained what the issues are? Have we given them time to improve? Have we given, yeah, you're raising it there, have the concerns been raised in the past? Have we documented them? Has the assistant in turn raised any comments? And, you know, have we got a documentary trail? It goes back to that, you know, early conversations. Is that the case? And that is what I would be wanting to look at, as some of you have flagged, in terms of how do we take this forward? Because if we haven't had those conversations, if we haven't documented, if we haven't given that opportunity to improve, then I would have concerns. And again, is there an underlying issue or concern from the assistant's perspective? Yeah, we want to know, are there any issues here? Are there any protected characteristics? Perhaps they're not performing because of a health condition that they or something else. So if we go on to the next slide. So we're now going to go into a question for you. So the various managers inform you that they have had several conversations with the assistant. So we know the conversations have taken place. We didn't know that before. She's not given any reason for her lateness and poor attitude. She's not improved her punctuality or attitude despite being given the time and support to improve. The managers do not consider this. She has completed her probationary period to a satisfactory standard. Would you terminate her employment on the basis she's failed to complete her probationary period to a satisfactory standard? Well, you know, based on the information, you know, we're majority going yes with this. We have had the conversations. We've given her time to improve. She's not improved. Obviously, she's coming up to a probationary period. We've got no unfair dismissal rights that we're concerned about. We're not aware that any sort of discrimination issues have been raised. So I would be with the yeses. I'd feel comfortable in terms of saying, I don't believe that you've met the expectations that we have. So I would agree with that. If we go on to the next slide, you invite the, oh, it says employment, but it should be the employee, to the 3-month probationary review meeting. At the start of this meeting, the employee informs you she is pregnant. You congratulate the employee and ask her how she's been feeling. She confirms, fine, I've been really lucky. I've had no tiredness or morning sickness. I don't feel any different. Would you terminate her employment on the basis she's failed to complete her probationary period to a satisfactory standard? So the figures are changing slightly now in terms of those saying yes and those saying no. So we've got 40-40, 21% not sure. And, you know, I think that is completely understandable. You know, we've had a suggestion, wouldn't you just extend and address the issues? Yeah, I mean, look, in terms of, we know now, we're on notice, aren't we? There's a protected characteristic there. What I would be interested in as well is she hasn't attributed any of this to or her performance. We've not yet discussed it yet, but so far, you know, she hasn't said, I feel really ill, it's really affecting me. So we don't know to what extent her pregnancy is impacting, but clearly, you know, we are on notice. She could say, if we end her probationary period, she might say, well, I believe you're discriminating against me. Now, we would say, of course, well, no, we've had conversations with you. We do not believe that is the case. I think if she's attributing it, her lateness and her attitude to morning sickness, her condition, yes, I would certainly be giving her time frame to improve and support to improve. But I would want to know more about, well, why is that the case? And either way, we know there is a protected characteristic here, so there is a risk factor that we need to be mindful of in terms of how we manage this. If we go on to the next slide, we've just had the suggestion of a pregnancy risk assessment and extend the probationary period, all very sensible suggestions. You then go on to discuss the employee's performance to date. She acknowledges she has been late, but she says she's only been late on 2 occasions because her car is not reliable. She disputes she has a poor attitude to work. You confirm that because of these issues, you've decided she's not met the standards expected. and unfortunately has not passed her probationary period. The next day you receive a call from ACAS confirming she has entered into early ACAS conciliation and is alleging discrimination. What steps could have been taken to protect the business in these circumstances? Well, I don't know if you've got any suggestions, please put them in the chat, but I would certainly be saying I'd want to ensure that we have got documentary evidence of how we've managed her to date. You know, we've said that these managers have had conversations with her about her performance. Have we got those documented? Because we can therefore demonstrate that the decision that we have taken is based on those conversations. Yes, of course, she's raised that her pregnancy, that she is pregnant. She hasn't attributed her performance or how she's behaving to her pregnancy here. She's just said, I'm not affected by my pregnancy. I was late because my car's unreliable. I dispute that I've got a poor attitude. So there's nothing attributed there, but I'd want to see that we've documented it. And the reason why that is so important is if we do not have that, then it would just be a case of those witnesses giving oral evidence in a tribunal setting, if it gets that far. And, you know, you as a witness are going to be far more credible if you've got a document that is contemporaneous from the time that says you met with her, what the issues are, what had been discussed. Also, in terms of the letter confirming that probationary period has not been extended, have we set out in detail that why we've made that decision? What's the rationale behind that decision? Have we got reference to the conversations we've had? Again, it makes us more credible. It documents what steps we've taken.
Can I just say, Fiona, on that as well, just briefly? Fiona's absolutely right. And I think some employers think it's kinder not to outline somebody's shortcomings in a dismissal letter. So we have seen employers tripped up with that, where they have simply said, you have failed your probationary period. And clearly, if we're dealing with a situation like we are now with a protected characteristic at play, that leaves us open for the employee to say, it wasn't, you've not said why I failed it. It's because I told you I was pregnant in my review. So I think it's a tricky one, because I think sometimes people are inclined to not want to hurt people's feelings by telling them that they're bad at their job. But sometimes it's really important to tell people that they weren't doing so great at their job. And actually, even if it's a couple of bullet points, you know, in that termination letter, you're then not dealing with, you know, a complete question mark over why it might be, if you've at least given a, you know, an outline on why. Okay, thanks.
And the thing is, you know, when you then end up in tribunal, the judge will say, and I've had judges ask, how did you come to your decision? Why is that not in your letter? So you would be asked a question, and you might say, well, I didn't want to hurt their feelings, but it makes you more credible if you've backed up what you're saying. In terms of how you'd engage with ACAS, in the 2 minutes I've got left, I'm going to quickly say, well, I think it's about finding out what this individual is seeking, about putting our case forward. It might be, and I've done this before, where we've kind of set out why we believe it is not the case. And it might be that you disclose those conversations, the notes of meetings, so that we can say this wasn't about pregnancy, this was about her performance. We'd had numerous conversations. So they're all things that you can think about, but we need to put our case forward. And then I suppose it is a case of considering what this individual wants. We are quite clear in terms of we've not discriminated, therefore do you want to wait and see if she brings a claim, or would you consider a low commercial settlement in order to avoid the costs of having to draft a grounds of resistance? That's obviously a business decision to make. So that is our introduction and kind of covering the basics. Verinda's back, so I'll hand over to Verinda, but any questions, please do follow up with us. More than happy to answer them, and hopefully we'll see you in September for a mock tribunal in person. Verinda, over to you.
Thanks, Fiona. Thanks, Melanie. That was insightful as always. So thank you, everybody, for joining. Any comments, any questions, and any suggestions for anything else that you guys are interested in hearing about, talking about, then please do get in touch with us, and please do let us know. And watch this space for that in-person mock tribunal invitation coming out over the next month or so to you. Thanks, everyone.